Yes, Mr. Adley.
May it please the court, I appear on behalf of the appellants.
Yes.
My learned friends, Mr. Jaffe KC and the group appear for the respondents, the 3million and the All Open Rights group. And my learned friend, Mr. Knight, appears for the Information Commissioner, the interested party.
Would you mind speaking up?
I beg your pardon, yes.
It's a very big court.
The appellants are named as the Secretary of State for the Home Department and the Secretary of State for Culture, Media and Sport. The first appellant is there because it is his department, which is the controller in this case, the person who does the processing. DCMS was there because at the time of the original hearing, it was the department with responsibility for data protection legislation. Yes. That has now been moved to the Department for Science, Innovation and Technology. And when your lordships come to make your order, I'll invite you to substitute that relevant Secretary of State.
Well, you better give us the proper title of the right Secretary of State.
Yes.
And we will order a substitution.
I'm grateful.
I can tell you that we have read, obviously, the judgment below. We've read the skeleton arguments, and we have read those passages in the authorities to which you have referred in your skeleton arguments, plus the regulation, obviously, and the explanatory memorandum.
I'm very grateful for that indication. In terms of timetable, there's agreement at the bar. I'm going to open my appeal this morning. I may go slightly into the afternoon, but not very far into the afternoon. Mr. Jaffe will then begin his response this afternoon. May need to go over into tomorrow morning. Mr. Knight will respond to the extent that you invite him to in light of whatever points left to be made, and I would then ask to respond finally for half an hour or so tomorrow morning. So the time estimate of 2 days is ample. We may well be finished by...
Sounds like a day and a half.
Yes.
Right.
Before I begin the detail of my submissions, as you'll appreciate, this is an appeal against a decision of Mr. Justice Saini that the amended immigration exemption under paragraph 4 of Schedule 2 of the Data Protection Act 2018 is unlawful because incompatible with EU retained law. That's to say the UK GDPR. And there is, of course, history here because the original exemption in the 2018 Act was declared unlawful by this court, again because incompatible with EU law, as it was then. That was in 2021. And the judgment of Mr. Saini, Mr. Justice Saini is to the effect that the steps taken to cure the inadequacies in the initial exemption were insufficient. As one would expect, the judgment of Mr. Justice Saini is impressive, but we say it suffers from two fundamental flaws. Firstly, it overstates the requirements as to what an exemption must look like to qualify as a valid exemption under UK GDPR Article 23. And secondly, it understates the features of the immigration exemption, which we say do now achieve compliance with that article. And of course, at the heart of this case is the government's decision to require the Secretary of State to have in place with regard to a policy document that explains how the exemption should be applied in practice. That has been a source of controversy and, dare we say, some confusion. It's described in the judgment and by the other parties as somehow impermissibly contracting out important safeguards that are required to be included on the face of a compliant exemption to a document which is not law, but a non-binding policy document. We say that's a misunderstanding of the role of the document. We say all the safeguards that are needed to ensure that the immigration exemption is exercised in a lawful and proportionate manner are set out on the face of the exemption itself. One of those safeguards is the requirement to have in place, publish and have regard to a policy document. But the policy document itself, its contents, it is additional guidance for decision makers. it's not the location of the safeguards that are necessary to ensure compliance with retained EU law. Before I get to the grounds of appeal, I need to spend some time in exposition. So I'm going to structure my submissions as follows. I'll begin by taking the court to the exemption itself in its amended form. Secondly, I'll address you on the evidential and contextual matters that are mentioned in the judgment. Thirdly, I'll show you Article 23 of the UK GDPR and what it requires according to this court in the first judicial review proceedings. Fourthly, I'll show you some of the European case law that is cited by the judge below. And then I'll work through my grounds 1, 2 and 3 and with the points raised in the respondent's notice. I won't need to say very much about ground 4 because the stay that this court put in place has essentially put that to one side, but I will address you at the end of my submissions with an update on instructions about the timetable that would be needed if I'm not able to persuade your lordships and you do uphold the judgment of Mr. Justice Saini in whole or in part.
You say on instructions, but one of the complaints I think that's made is that you were asked to put in evidence below, and certainly my recollection is that in the previous case in which I was a member of the court, there was evidence placed before the court, and then we had a remedies hearing, and then, as you know, there was a separate remedies judgment. So don't we have to act on the basis of evidence?
Yes, and there is evidence in the form of the statement of Mr. Prince, which is the first tab in the bundle.
I've seen that.
By way, in terms of saying by way of update, it's simply to explain what certain contemporary matters in the parliamentary timetable might mean.
I see.
But if your lordships would like it to be put in witness statement form, I'm sure that could be achieved overnight.
I see. Well, let's see how we get on.
Can we begin then with the exemption itself? And it appears at various places, but I'd invite you to look at the version that is in the supplementary bundle, tab 3, page 84. That's a helpful place to look because it shows not only the additions but the deletions, so you can see all the changes that have happened by way of amendment.
Page 154.
Page 84.
84. Yeah. We're using the numbering at the bottom rather than the top there.
Yes, that's the numbering I've been using. But I'll give both numbers when there are options. So, paragraph 4, little 1 says that the listed provisions don't apply to personal data processed by the Secretary of State. So it's an exemption that applies only to the processing by one controller, that we say. And the judge agreed with us on that, although it is challenged in the respondent's notice. And I'll come back to that when I deal with my respondent's notice points. But
that replaces subparagraph 3. Is that right?
Well, subparagraph 3 comes out because of that change.
Yes, exactly.
It was unspecific as to which controllers previously, and obviously paragraph 3 contemplated a multi-controller situation where you might have a public authority and a private landlord, for example. That's now gone. It's plainly only processing by the Secretary of State. So in that sense already substantially narrower than the earlier exemption. Then it says it applies or can be disapplied to data processed for two purposes: the maintenance of effective immigration control or the investigation or detection of activities that would undermine the maintenance of effective immigration control. Again, we say that's a clear and specific purpose. And the judge again agreed with us on that. Again, Mr. Daffy raises that in his respondent's notice. He wants to revive his argument that that is an impermissibly vague statement of purpose, but we say it's clear and narrow, and I'll explain in the course of my submissions why it would be self-defeating if one were to try to make it any more narrow. And then the third point to note on this subparagraph is that the disapplication only works to the extent that application of the provisions would be likely to prejudice any of the matters mentioned above. There's controversy about the meaning of that phrase, to the extent that would be likely to prejudice, or at least there's controversy about whether that meaning ought to be spelt out to greater extent on the face of the exemption. And that's what's raised in my ground one, which I'll come to. But one can note immediately that this is not a blanket exemption that always applies whenever the Secretary of State is processing data for immigration purposes. It's limited as to what rights can be curtailed, as to the information that can be withheld, and as to the duration. Plainly, it's a time-sensitive matter. Something might be sufficiently prejudicial at one point and lose that prejudicial aspect at a later point. And as I'll explain when I come to ground one, that formula, to the extent that would be likely to prejudice, is a frequently used one in data protection law. By my calculation, there are 9 other exemptions in Schedule 2 that use the same formulation, and it's a formula with a clear meaning. Before I come to the additions that begin with 1A, 1B, etc., can we look at little 2, which tells you which provisions may be disapplied under this exemption? And it may be helpful to have the UK GDPR open at the same time so one can look at what those rights are. The UK GDPR is in the second file of the authorities at tab 32, and the relevant page is 1574. So the first right that can be disapplied is Article 13. That's information that must be provided to a data subject, usually when they're collected directly from the data subject. In practice, it's what you see in a privacy notice, typically. Article 14, over the page, is the equivalent provision for where the data are being collected from a third party rather than the data subject themselves. And typically, again, this is information that's provided to data subjects in a privacy notice. You will note that in Article 14.5, on page 1577, there's already an inbuilt disapplication of this obligation. So it's a qualified right in any event. It doesn't apply where, for example, in little b, provision of the information would be impossible, would involve disproportionate effort, or insofar as the obligation referred to in paragraph 1 is likely to render impossible or seriously impair the achievement of the objectives of that processing. So there will already be situations in which a data subject is not given full information about processing of data obtained from third parties, but in reliance on that sub-paragraph. That's before one even gets to an exemption. The next right that is restricted, or may be restricted under the exemption, is Article 15, on the same page, 1577. And this is the important subject access right. We entirely accept it's a very important right, sometimes called a gateway right or a foundational right, because it allows the data subject to find out what is being done with their data, and if necessary to bring further challenges to that processing. But that too has something of a built-in qualification, because if you turn over onto the next page, little 4, the right to obtain a copy referred to in paragraph 3 shall not adversely affect the rights and freedoms of others. So again, there can be situations in which, even without referring to any exemption, it's necessary and justified to withhold certain information in response to a subject access request where that would impinge on third-party rights.
Does the omission of Article 15.2 mean that if data are transferred to a third country or international organisation, the data subject has all the rights in Article 15?
Well, it's the right to...
Oh, it's 15.123.
Yes, so that they all stand together.
That goes as well.
Yes. Now, the next right in the UK GDPR is the right to rectification, the right to have inaccurate data corrected or incomplete data supplemented. That is not a right which is affected at all by this exemption. It's omitted from the list here in paragraph 4, little 2.
How will the data subject know what information has been recorded if the data access, the subject access rights have in fact been supplied? You won't have the faintest idea, will you?
Well, they may do. I mean, they can write. I mean, your lordship is right, which is why I completely accept that Article 15 is a gateway right. It's the way you find out what data is being held. There are other ways, and you can, if you're dealing with Home Office Immigration Services, you can write and say, this is my true data, this is who I am, this is where I was born, please confirm this is what you, that your records are accurate, and if not, correct them. But I accept that something.
And the Home Office can say we neither confirm nor deny, can't they? If they've disapplied 15.
They would have to, they may do if they disapplied 15. They may do, but I'm going to explain the very narrow circumstances in which such disapplication can actually occur when the exemption is properly interpreted and applied. The next right that is restricted is the right to erasure, the right to be forgotten, as it's sometimes called. That too is a highly qualified right. It doesn't arise in all circumstances. You have to get into one of the 6 categories in Article 17.1a through to F before you have even the prima facie right to have your data erased. And again, there's a built-in qualification on that in Article 17.3, which says that it doesn't apply to the extent that processing is necessary for, among other things, the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. So again, a right that is quite limited, even before one starts calling upon an exemption to disapply it further. Article 18 is also restricted. That is the right to have processing restricted. That's quite a limited right. What it does is requires a controller merely to hold but not otherwise to process data in certain defined circumstances. For example, while a public authority is considering an inaccuracy complaint or an objection to processing. The next right that is restricted by this exemption, or maybe, is Article 21.1. That's the right to object to processing. You can see that on page 1581. again, not an absolute right, even before one starts looking at an exemption to it, because what it obliges the controller to do is stop processing the data once an objection is raised, unless the controller demonstrates compelling legitimate grounds for processing which override the interests, rights and freedoms of data subjects. And last of all on the list of rights that may be restricted under this exemption is Article 5 General Principles, so far as its provisions correspond to the rights and obligations provided for in the previous mentioned subparagraphs. So this is not a measure that can be used to opt out of the core principles of data processing. Whatever you do, you must always process data lawfully, fairly and transparently. You mustn't process it for any longer than necessary. This provision is here because occasionally there will be an incidental infringement of Article 5 if there's also a disapplication of one of these listed articles. So, for example, if the Secretary of State relies on the exemption to omit information that they would otherwise provide to the data subject under Article 13 or 14, that would bring it into conflict with the transparency principle in Article 5(1)(a), and to that extent, therefore, that principle is disapplied in parallel, but it goes no further than that. So those are the rights that may be disapplied, and it's important to have those in mind, we say, that when working out what an exemption that permits disapplication of those rights needs to look like in order to meet the necessary legal standards. Going back then to the exemption in its amended form, we then have 1A, which says that the exemption can't be applied unless the Secretary of State has an immigration exemption policy document in place. And then 1B says what it means to have such a policy in place. It has to be a document that explains the Secretary of State's policies and processes for A, determining the likely to prejudice test, or B, if the likely to prejudice test is met, policies and procedures for preventing the abuse of the personal data and any access to it or transfer of it in unlawful circumstances. And when I come to my ground two, I'll explain why these requirements are requirements with real teeth. 1C then moves you on to look at paragraphs 4A and 4B, which it describes as additional safeguards. You see those over on the next page, page 86 at the bottom, CP 156 at the top. Those additional requirements are to make any determination on a case-by-case basis and to have regard to the policy document. But then there's a duty to keep it under review and a duty to publish it in any update. And ultimately, there's a record-keeping obligation. Secretary of State must keep a record of when the exemption has been deployed. And last of all, a duty to inform the data subject if the exemption has been applied, unless that in itself might undermine its effectiveness. So those are the features of the exemption that is under challenge or has been found to be unlawful by the judge, and I I hope by looking at them now we can have them firmly in mind when we come to the actual arguments on the grounds. The second heading I mentioned was the evidential and contextual matters that the judge lists in his judgment. It's a passage that starts at paragraph 25 of the judgment, which is in the core bundle, tab 10. And it's the passage that begins on page 128. As he correctly records, no one in this case is disputing that some sort of immigration exemption is needed. It's common ground in this appeal, as it was below, that effective immigration control is an important public interest that the government is entitled to pursue. And it's common ground that the unrestricted application of the data subject rights I've just shown the court may, in some circumstances, undermine or frustrate that important public interest. Then, paragraphs 25 through to 28, the learned judge summarises the uncontested evidence in this case about where the need for an immigration exemption arises from and how it's being used in practice. We have no complaint with the summary of that evidence there, but I would ask the court to look at the underlying witness statements. The references are, first of all, the first witness statement of Miss Samdi, paragraph 61 through to 64. That is in the supplemental bundle, tab 3, page 45. That is evidence that was given in the first judicial review proceedings, but it was redeployed in this case by way of background. And the second witness evidence I'd ask you to look at is the witness statement of Mr. Prince. That's the witness statement that appears at tab 2 of the supplemental bundle, beginning at page 15, and in particular paragraphs 16 through to 25 and 53 to 63. That was evidence prepared for these proceedings, and it builds on what Ms. Samdi says and addresses the application of the exemption since it was amended. As I say, I'm not going to read you through that evidence now, but can I make some points on it that I hope will emerge when you do read it? First of all, one is struck by the sheer variety and extent of data processing that is now undertaken in the context of the immigration world. That's the point made by Ms. Samdi in particular. You can also get a good illustration of it by looking at the relevant Home Office privacy notice. You can see that in the supplemental bundle, tab 3, page 114. Using the bottom pagination, top pagination is CP1/84. So this is what's known as the Borders Immigration Citizenship Privacy Information Notice. And you see on page 117 in the introduction a summary of the many ways in which the Home Office needs to process personal data. And then there's an even more detailed list beginning on page 119. A number of bullet points carrying on all the way to page 122, listing all the multifarious ways in which personal data may have to be processed in order to operate the immigration and asylum system appropriately. And your lordships will be aware, simply from news stories and indeed looking at the life of this case, how the focus of immigration matters changes from time to time. When the evidence went in JR1 in this case, there was much talk about the Windrush scandal at that point. Then we had Brexit, new rules and restrictions on EU citizens wishing to remain here, another different type of data processing problem. Most recently, of course, it's the small boats crisis. So there's a changing focus, as well as a very wide range of processing that has to be done. And that is why we say it's particularly difficult to define a priori what processing operations or data ought to be exempted. That is why the legislator has chosen a likely to prejudice test rather than a list of categories of types of information or types of processing that ought to be exempt. The second point that arises out of the evidence I referred you to is that probably the paradigm point of conflict between full application of data subject rights and the effective control of immigration is the subject access request. A subject access request made under Article 15, and the danger, as Ms. Samley puts it, of tipping off the data subject that may be about to be the subject of investigation or enforcement action, removal, allowing them to take evasive action. But it's clear from her evidence and Mr. Prince's evidence that is not the only point of potential conflict between the subject rights and administering the immigration scheme. She gives other examples. An objection to processing or a right to erasure request may interfere with profiling work that's being done to assess whether somebody is moving around in a way that's inconsistent with the residence rights they've been granted, or entering into a sham marriage, for example. She gives an example that disclosing caseworkers' notes at the time that they're looking at an application of some sort, assessing its veracity, that might allow the data subject to frustrate that by either creating false corroborative evidence or suppressing evidence. An important point that comes out of Mr. Prince's statement in particular is the danger of full access rights being exercised by the data subject, resulting in information about the Home Office's own intelligence gathering systems, that you'll have seen reference to the warnings index. And Mr. Prince makes the point that if a data subject is told that in their case the warnings index has been consulted, and they either appear on it or they don't, that is in itself information that may be of use to someone who's seeking to evade immigration controls, because they know that the nature of the intelligence or the extent of the intelligence that may exist about them. And as we'll see, that is probably the case in which the redactions from subject access requests is occurring the most. It's the withholding of small snippets of information that would simply allow the data subject to know whether a check's been done on the warnings index and whether it came back positive or negative. So, continuing with my list of areas where there's potential conflicts between full data subject rights and proper administration of immigration matters, another example Mr. Prince gives is where full disclosure would have breached an international agreement and thereby undermining the cooperation that's very important in immigration matters between the UK government and other governments. So given that these conflicts can arise in so many different ways, it would be inadequate, for example, to take out the would be likely to prejudice test and, for example, replace it with if full response to the data subject rights would undermine enforcement action. That would be too narrow a formula to capture all the ways in which there may be a conflict. And that is why we say that the would be likely to prejudice test, once you construe it properly, which I'll come to under ground one, is the proper way to balance the rights of data subjects with the processing that needs to be done for immigration purposes. The third point that comes out of the evidence I referred you to is the limited use that is being made in practice of the amended exemption. And we say that's not happenstance or restraint by decision makers. We say that is a function of the narrow terms of the exemption itself. Mr. Prince gives you some figures. He says that at the time of his witness statement, he'd looked at 9,275 subject access requests, and that the exemption had been used in 6,111 of those. Now, that sounds like a high proportion if you simply state it as baldly as that. But then he explains that in most of those cases it will be very, very minimal withholding of information at all. The classic example being a reference to the warnings index or not. And in some of the examples he gives, he refers to a subject access response that was 104 pages long, out of which about a quarter of a page was redacted. His second example, 2 pages out of 167 pages. And the third, half a page out of 129 pages. And the last point I want to make on the evidence, you'll notice that Mr. Prince says that in all the examples he cites, the data subject was told that the exemption was relied upon. So even though they can't know what's under the redaction, they at least know why something's been redacted, and they can look at the exemption and work out if there's a basis for challenging it, asking for redactions to be removed. Then, going back to the judgment, after the judge has summarised that evidence, he has a heading, Important Contextual Matters. And again, we don't raise any major objections to this, but there are some points of emphasis that we could perhaps gently make. The first contextual matter, he says, in paragraph 31, is that the data to which the exemption is applied is inherently likely to involve special category data, so racial or ethnic origin data, for example. There's perhaps a confusion there, because of course this exemption cannot authorise the processing of special category data. That has to be sourced elsewhere. You have to find the legal basis elsewhere. Special category data is a prohibited area of processing under Article 9 of the GDPR, which I'll show you later in my submissions. unless certain grounds can be made out. And Article 23 exemptions can't change that. But we also say it may be slightly overstated here, because while, of course, an enormous amount of immigration data will be special category data, such as that, we say it's highly unlikely that is data that could be properly withheld from the data subject themselves, for example, in response to a subject access request. How would it be prejudicial to immigration purposes to let a data subject themselves know what records you have as to their ethnicity, gender, etc.?
Well, there might be a case, mightn't there, when the data subject says, I come from country X, which I am fleeing to avoid persecution, and the Home Office thinks, no, you didn't, you came from country Y, which is perfectly safe.
Yes, but that wouldn't... Well, that's nationality.
We are investigating whether you actually came from country Y. And we don't want to tell you about that.
Yes, there may be circumstances in which there is a sensitivity of that kind. In the vast majority of cases, we would suggest that is not something that's going to arise and stop the data subject being told what records are held about their own ethnicity, gender, and so on. The second point the judge makes is a contextual point, paragraph 32. Data subjects in these situations inherently like to be in a vulnerable position, but we certainly don't disagree with that. It won't be all of them, of course, but obviously the system has to be worked in a way which does protect the most vulnerable. Then he makes a slightly odd observation that it's relevant to note that these are precisely the sort of circumstances in which processing of the subject's personal data on the basis of genuinely freely given consent is unlikely. Well, no doubt that's right, but consent is just one of 6 legal bases on which data can be processed. And we say it doesn't follow that greater protections are necessarily needed for data subject rights just because the legal basis for processing is a non-consensual one. True, of course, if consent is the only legal basis for processing, then the data subject has it in his gift to bring that processing to an end by withdrawing their consent. But we say that doesn't then lead to the conclusion that processing lawfully on some other basis is inherently more risky or inherently more unfair. The third, fourth contextual matters the judge mentions we have no dispute with or observations about at all. And the last one is about the extent of use, and I've already referred you to Mr. Prince's evidence on that. The headline figure of the number of cases in which the exemption is used, we say that gives you a slightly skewed view of things because one has to take into account how it's being used in a very limited and focused way in those cases where it is used.
Would you say that even if the exemption had been drafted and promulgated in the manner which the judge ultimately concluded it should have been, in other words, on the face of the legislation, that these contextual matters would still apply?
They would indeed.
So do you have a submission? I don't know, speaking for myself, I'm not entirely clear what the point is that's being made, but it may be that I'm not seeing something that you can.
The point being made by the judge is that there's a particular need for specific detail on the face of legislation which is going to be operated in such a sensitive context as immigration. We accept that as a matter of principle. When one looks at what proportionality and necessity requires in any particular given situation, you look at the sensitivities, and it's his view of those sensitivities that draw him to the conclusion that more is needed on the face of the exemption, but we say we accept those sensitivities subject to the slight overstatement that I pointed out.
Yes, thank you.
So those are the evidential and contextual matters. May I turn now to Article 23 of the UK GDPR itself, and then to what the Court of Appeal said about it, or rather about its predecessor. So, provisions back in the Authorities Bundle, Part 2, 35.
I'm so sorry, where are you going now?
I'm now coming on to the third of my headings, which is the Article 23 itself and what the Court of Appeal said.
Where are you referring
So
to?
I'm now taking you to tab
32, page 1583.
Thank you very much.
Yes, thank you.
Yes.
This is the amended form following IP completion day, and you see it begins, the Secretary of State may restrict the scope of obligations and rights provided for in those listed rights. And then if you look down to little 3, you're told how the Secretary of State must effect any such restriction. He must do it by making regulations under Section 16 of the 2018 Act. Prior to IP completion day, when this was the UK GDPR, the wording instead of what's in the square brackets at 1 was union or member state law may restrict by way of legislative measure, and then carrying on. And as Mr. Knight, the ICO, says in his submissions, regulations are simply the appropriate domestic form of the legislative measure that was referred to in...
If it said by making regulations and or by issuing a policy document or a code or something, if it made express reference to something, some instrument of that type,
Yes.
on your submission, would there be any problem with that being lawful? Because in other words, the requirement that it has to be in regulations, does that flow from some fundamental principle of law in this area? Or is that simply the mechanism that the draftsperson of this instrument has chosen to adopt?
No, we would accept that that reflects the fundamental approach in this area, which is you need something that is law as opposed to soft guidance.
Well, that may beg a lot of questions with respect, because in other contexts, it's well established that, for example, a statutory code, I think the judge accepted this, a code of practice, even a policy document, depending on the context. In prison law, sometimes I think Silver in UK, the Strasbourg case back in the mid-70s, having a policy in place can sometimes be sufficient to constitute, quote, law, unquote.
Yes.
But what I'm really asking is whether you have a submission on behalf of the Secretary of State about whether this had to include the word regulations or whether it might have been drafted differently. But by all means, come back to that if you wish.
Yes. No, it might have been drafted differently. Right. It would have come... There would then have been questions whether whatever different drafting did meet the standards of EU law that is attempting to be articulated here. But yes, it could have been drafted differently.
Thank you.
But the fact that it now says regulations, in our submission, really puts the focus onto the next bit, because we do have regulations. What we have to have is regulations which create a restriction that respects the essence of the fundamental rights and freedoms and is a necessary and proportionate measure in a democratic society to safeguard one of those listed matters. And you'll see in the CJEU cases, sometimes they come at the question as to whether they're dealing with law at all, as to whether it's a restriction or whatever is provided for by law. They tend to do that where there's some doubt about the type of instrument they're looking at. Other times they come at it, effectively raise exactly the same matters in terms of necessity and proportionality. Because as the Court of Appeal rightly says, and I'll show you what the cases say, that if you are having a derogating measure from a fundamental right, you can't simply say on its face that this must be used in a necessary and proportionate manner. You must have some more detail on the face of it to explain what is a necessary and proportionate use of the measure. And then Article 23(2) carries on, in particular, provision made in exercise of the power in paragraph 1 shall contain specific provisions, at least where relevant as to, and then a list of specific things that have to be addressed, at least where relevant.
Provision made in the exercise of the power means in the regulations.
It's in the regulations.
In the regulations themselves.
Yes. At no point in my argument am I suggesting that the policy document itself fulfills the role of the regulations, is part of the regulations, is law. It's the regulation itself that satisfies the criteria here so far as relevant, because when you read the features of it together that I've taken the court through, they combine to ensure that it's an exemption that can only be used in a manner where that's necessary and proportionate.
So you're not relying on the body of case law, which certainly in the ECHR context and possibly in the EU context says that sometimes cross-referring to a policy document can constitute law. You're not saying that.
That's not my case.
That's very helpful.
It's the four corners of the regulation you look at. The confusion arises because one of the safeguards is the requirement that there should be a policy document. That doesn't mean make a policy document part of the law.
Yeah. So just to be absolutely clear that I've understood your submission correctly, when the judge said that what's happened here is that something which ought to be in the regulations has been, quote, outsourced, unquote, to a policy document.
Yes.
You don't, I think, dispute the underlying principle that that's not lawful. You couldn't outsource something that needs to be in the regulations.
We agree with that principle, absolutely, yes.
What you do dispute is that that's what's occurred in these circumstances.
Here, yes, because we say all the necessary restrictions, etc., on the face of regulation, content of policy documents, icing on the cake, if you like, detailed guidance for administrative decision makers when they're applying the exemption as set out on the face of the regulation.
You say it's icing on the cake. Does that mean that if you didn't have a policy document at all, that you would say the legislation is still compatible with Article 23?
No, because one of the safeguards is the requirement that there must be a policy document.
I see.
The requirement to have a policy document to follow it promotes conscientious decision making. The content of the document is there to assist on a detailed administrative level. So that's the wording of Article 23. It's necessary now to look at what this court said about it in the first judicial review. I've set out the key parts of the judgment in my skeleton, paragraphs 24 to 33, but I can just take you through those parts of it in the authorities itself. It's authorities bundle 1. Tab 12. And it's important to remember that the government at this stage was not trying to persuade the court that the original exemption did have all the features that were necessary under Article 23.2. What the government's case was at that point was that you can look elsewhere. You can look into the wider scheme of the law, human rights law, administrative law, and so on. You pull all that into the picture and then say this exemption is going to work fine once it's judged against that background. And the short point the Court of Appeal decided was that's wrong. You can't pull in wider matters. You've got to look at the derogating measure on its face and see whether it ticks enough boxes under 23.2 as are necessary in order to ensure proportionality. And so that's the reason the decision can be so simply stated at paragraph 29 on page 436, where Lord Justice Warby says there presently exists no legislative measure that contains specific provisions in accordance with the mandatory requirements of 23.2. In the absence of any such measure, the exemption is unauthorised derogation from fundamental rights. But, paragraphs 32 and 34, this court explains the relationship between paragraph 1 and paragraph 2 of Article 23. In other words, as it's put in paragraph 33, Article 23.2 contains a condition precedent to the validity of any legislative measure. In other words, it's before you can get to the 23.1 question of whether you're looking at something which has the quality of law and which meets the standards of necessity and proportionality, you have to have ticked as many Article 23.2 boxes as may be required. And again, quoting Mr. Knight at paragraph 34, the natural reading of the wording used is that the legislator sees the specification required by 23.2 as a way of securing the proportionality required by 23.1.
And the reason why the court is talking about the measure is because at that stage it's looking at the EU GDPR, which talks about legislative measure.
Precisely so.
In the light of the way that the exemption is now drafted, we can replace the measure with regulations.
Yes.
So the regulation can only satisfy Article 23 if it, that is the regulation, contains specific provision as to each matter listed, which is relevant.
But which is relevant, which then begs the question, relevant to what? And you start to get the answer to that in paragraph 33. In the circumstances relevant to an assessment of whether the measure respects the essence of the right in question and is necessary and proportionate. So that's the test of relevance. You look at what's needed by way of specification in order to secure the proportionality that's required in paragraph 1. Then the judge moves on to the European cases. And paragraph 36, that having listed a number of cases, he says, I would accept that the cases show the CJEU has been alert to the risk of overboard derogations from fundamental rights, requires any derogation from fundamental rights to be justified by proof of strict necessity, and does not consider that this or the requirement of proportionality can be satisfied unless the appropriate safeguards are built into the legislative measure. That is what you get from those cases. I'm not going to have need to take into all of them because we completely accept that that is the conclusion that can be drawn from them. What it doesn't say, as I'll develop in a bit, is what any particular derogating measure should look like, a particular derogating measure under Article 23.
I think it may be worth just noting the second half of paragraph 37. Because,
yes,
in a sense, there was a sort of negative point that was being made. My recollection, and I may be wrong, my recollection is that the first instance judge in that case had drawn a distinction, which I think he said derived from the EU case law. And what Lord Justice Warby, I think, is saying here is that actually I don't see that distinction.
yes, there's no distinction to be drawn between a permissive measure, such as you may disapply certain rights, and a directive measure. This right will not apply.
Yeah.
But that's not a distinction we're seeking to draw in this case. There's a little bit more to look at in the Court of Appeal's judgment about this concept of relevance. First of all, at paragraph 50, again drawing a conclusion from the European cases, this interrelationship between a number of specific matters being mentioned on the face of a regulation and the ultimate aim of securing proportionality is made once again. Lord Justice Warby says the essence of the reasoning, as I see it, is that the broad legal provisions, such as those that require a measure to be necessary and proportionate and proceed for legitimate aim, are insufficient to protect the individual against risk of unlawful abrogation of fundamental rights. And the framework won't provide the citizen with sufficient guarantees that any derogation will be strictly necessary and proportionate unless the legislature has taken time to direct its attention to the specific impacts which the derogation would have, consider whether any tailored provisions are required, and if so, to lay them down with precision. And that approach will tend to make the scope and operation of the derogation more transparent, improve the quality of decision making, and facilitate the review of proportionality. So again, the intrinsic link, we say, between what needs to be picked out from the Article 23.2 list and the ultimate aim of securing proportionality.
Can I just ask you a question about that paragraph?
Yes.
Because again, like my lord, it may be that we now have to read that in a slightly modified way, because at that time we were dealing with primary legislation,
yes,
which of course had been enacted by Parliament.
yes.
So I don't know, that may be an explanation why the judgment here refers to the legislature. But
yes.
given that it now refers to the Secretary of State, may by regulations do something, do we have to read that so legislature includes in principle the Secretary of State?
Well, remember that the regulations have to be made under the affirmative resolution process, so they are. They must be laid before Parliament, debated by Parliament, and voted on by Parliament. So I don't think we do need to.
I see. So you would say that because of the affirmative resolution procedure, this paragraph still holds true, and legislature means legislature.
Yes, we have no difficulty with that. And yes, the last paragraph to show you is where something a bit more is said about the meaning of relevance. It's paragraph 54, between D and E. That it may be open to the legislature to conclude that one or more of the matters listed in Article 23.2 is not relevant to this particular exemption. It may even be entitled to conclude that although a particular matter is relevant, it's unnecessary to set limits any narrower than those contained in the GDPR itself. So, two potential types of irrelevance. One is that because of the nature of the exemption, the issue just doesn't come up. And I gave an example in my skeleton argument of an exemption that could only be applied by a domestic controller who's got no interest whatsoever in ever transferring data outside the EU. Such an exemption just simply doesn't need to address that prospect because it's just not within the scope of the process into which the exemption will apply. But the second type of irrelevance is where it's simply not necessary to pose any stricter limits than that are already part of the data protection law in order to secure that end of proportionality. So, for example, in this particular case, there's no restriction on the categories of data that may be become the subject of this exemption, and the respondents and the Commission take no point about that. They accept that it could nevertheless be a proportionate restriction so long as other features were there.
Can I just ask you about that? Because there's a little puzzle which I haven't resolved for my own satisfaction. That's certainly what Lord Justice Warby says in paragraph 54. But back in paragraph 48, between G and H, he has rejected Sir James Eadie's submission that specific provisions can be found in, leave out some words, existing articles of the GDPR. So he said, well, you can't look at the other articles of the GDPR to buttress what you're doing with the exemption, but then at 54 he seems to say yes you can. I'm not sure what the relationship is between those two statements.
I would submit it's not a contradiction. What the judge is saying is if you need something on the 23.2 list to be mentioned, it must be mentioned within the legislative measure itself. But when you're deciding whether it needs to be mentioned in order to secure proportionality, you can look at the other limits that are inherent in the GDPR itself. We would suggest that's not a contradiction. But the point I seek to make in my skeleton argument is that there is therefore a dynamic relationship between 23.2 and 23.1. You have to look at all of the conditions, restrictions, etc. in a measure like the regulation, work out how they interact together and work out whether they achieve proportionality before you come back and think, well, does it need more? Do we need something else off the 23.2 list, or do we need more detail of the matter on the 23.2 list before we secure that goal of proportionality? Let me try and give you an example of how that might work in practice. Imagine you've got a controller who's at a medical foundation that wants to conduct clinical trials. Two cohorts of patients are recruited for each trial. One gets a placebo, one gets the trial drug. Their health is monitored over a number of years to see how they do, taking into account all their lifestyle data as well. Data subject rights are capable of interfering with that processing, the purpose of that processing, because if you make a subject access request and find out whether you've got the placebo or the trial drug, that skews the process. If you object to processing, there's then a gap in the data record that the doctors will need to do a proper assessment of the trial. So an exemption of some sort is needed to reconcile data subject rights and the purpose of that processing. And you could do it in a number of different ways. You could have an exemption that simply says data processed for the purposes of a clinical trial is exempt. If you do that, you're going to need a lot more built into your regulation to make it a proportionate one, because that would put the trial data beyond the reach of data subjects for all time, even when the moment has passed when it ceases to be prejudicial to the conducting of the trial. So you might, for example, have to have a time limit provision, exemption only applicable for 3 years, or a tighter definition of what data is to be exempted. Data that's only capable of showing whether you're in the placebo group or the trial group, not other matters such as date of birth, address, and so on. But another way to do it is to say clinical data is exempt to the extent that compliance with data subject rights would be likely to prejudice the conduct of a trial. That's already got a built-in checks and balance because it will only operate for so long as those data do need to be withheld from the data subject in order for the trial to work. You don't need an extra provision then in about the time limit for which the processing may continue, or the time limit for which the exemption lasts. And that is the model that's been used in a number of places in Schedule 2 of the 2018 Act and used in this regulation that's under challenge as well. And we say it's a very potent formula because it has a built-in restriction that ensures a large degree of proportionality even before one starts looking at additional pieces of restriction that might be required. That's all I wanted to say about the Court of Appeal's judgment in this case. And to the best of our knowledge, it appears to be the last word on this matter. We found nothing either at European or national level that addresses Article 23 in that sort of manner. I said I'd say something about the CJEU cases. I don't need to go to all of them by any means. I'll concentrate on the ones that Mr. Justice Saini picked out and commented on in his judgment. The first one of those is La Quadrature, which he discusses in his judgment at 3738. And in the authorities bundle, it's in the first bundle at tab 20. This was a request for preliminary ruling concerning a challenge to French and Belgian legislation that obliged mobile operators to retain or disclose to public authorities the traffic and location data, and the national legislation said that was for the purpose of safeguarding national security and combating terrorism. And that was said to be in conflict with Directive 2002/58. That's often referred to as the e-privacy directive. Worth just showing you some features of the e-privacy directive. If you look in the judgment at paragraph 18, which is on page 873, Article 5 of that directive says member states shall ensure the confidentiality of communications and the related traffic data. So a prima facie duty not to look at or collect such data. And then in Article 6, a requirement to erase or make anonymous traffic data once it's served its useful commercial purpose. And then a similar provision over the page, Article 9.1, concerning location data other than traffic data. And then In Article 15, member states are allowed to adopt legislative measures to restrict the scope of those rights, but where that constitutes a necessary, appropriate and proportionate measure within a democratic society to safeguard national security, defence, public security and the prevention, investigation, detection and prosecution of criminal offences or unauthorised use of a communication system. And a requirement that any such derogating measure has to be in accordance with general principles of EU law. An important point to note then is here we're dealing with something that's completely prohibited and is then permitted in national law. It allows national law to make provision for processing of personal data that would otherwise not be permitted to be carried on at all because of those headline obligations of confidentiality. The reason the judge mentions this case is because it's one of the few cases that does mention GDPR Article 23, but it comes in a very oblique way indeed. It comes in, if you look at paragraph 79 on page 894, the question there from the Belgian court is, does the Privacy Directive preclude national legislation such that an issue which lays down a general obligation for operators to retain traffic, where, and by little g now, the objective is not only the investigation, detection, prosecution of serious criminal offences, but also safeguarding national security, etc. And then adds on, or the attainment of another objective identified by Article 23(1) of the GDPR. In other words, what the Belgian court is saying, well, we've got this list of things that we can breach confidentiality for, that they're listed in Article 15 of the Privacy Directive. Then we've got this list of different public objectives, public interest objectives in Article 23(1). Can we borrow that, please? Can we use that longer list of objectives in order to provide for the lawful monitoring, interception, etc., telecommunications? So it's an odd way that this provision is brought in, and it's slightly odd in how it's dealt with. What the court does first of all is give its absolutely standard explanation of what proportionality requires in this sort of situation. You see that at paragraph 132 on page 905. And it's the familiar formula.
By which paragraph?
Page 132.
Paragraph 132, yes.
Beg your pardon, paragraph 132, page 905.
Yeah.
And there we get the absolute orthodox statement of what a derogating measure must look like. We say orthodox, but also really not very illuminating as to what a measure would look like in this context, in terms of derogation from Article 23. Then, going ahead to paragraph 207 on page 921. The court turns to Article 23 of the GDPR. And I won't read you through all of it now, but it goes up to paragraph 212, it never really answers the question posed by the Belgian court. Can we borrow one of the additional public interest in Article 23? But what it says, and it's not quite clear why it decides to get into this, what it simply says is that what we've said about proportionality in respect of the Privacy Directive applies in a derogating measure under Article 23. But again, we say it's completely uninstructive as to what level of detail.
I mean, there's an intermediate passage, isn't there, at 168?
168 is the...
Where they're answering the question, and the question in paragraph 79 is question 1 in case C520/18, isn't it?
Let me just check back.
Page 893, the heading case C520/18. So that gets picked up again. The question the Belgian court asks gets picked up again at paragraph 168. They give an answer in that paragraph. And there's got to be effective review by a court or an independent administrative body, decision is binding and so forth.
Yes.
Same again at the bottom H. And then they would go back to that 207. And then they pick that up at 211, saying the findings and assessments in the context of the answer to given to question 1 in, amongst others, case C520/18 apply to Article 23.
Yes, we accept that, but what it doesn't address is the different context that Article 23 arises in. That list of matters that you've mentioned at page 168, those are all necessary things the court has said to achieve proportionality in the case of a scheme that allows the bulk interception and retention of mobile phone data for which there is no legal basis at all otherwise. Of course, those requirements are very, very stringent ones. It doesn't read across to an Article 23 context, we say, because Article 23 can never, an Article 23 exemption can never authorise processing that was not lawful. You must always show your legal basis for processing. And that's why it's slightly odd at paragraph 212.
So when the court says that it follows that the findings and assessments made in the context of the answer given to, amongst others, 520/18 apply mutatis mutandis to Article 23, how do you interpret that paragraph?
We would interpret that as effectively repeating what's been said at paragraph 132 of the judgment, so the classic formulation at a high level of generality about what proportionality requires in any situation where one is derogating from a fundamental right. Article 23 is about derogation from fundamental rights. I'm not disputing that, but it's not a measure that permits the bulk processing of personal data in the way that derogations under the Privacy Directive do. And you have to look at the rights that are being restricted in any particular context to work out what proportionality requires in terms of prescription on its face.
Do we need to look at the answer at the end of paragraph 212? What they actually conclude, Article 23 of the GDPR precludes. And it's interesting, it might be said to note how they frame what the national legislation there was doing.
Yes.
It provided for retention generally and indiscriminately of personal data relating to those services.
Yeah, that's why it's an odd sentence to interpret, because Article 23(1) could never permit, legitimise, authorise retaining data or processing data that was otherwise unlawful. It's about the restriction of data subject rights. And we would simply say it's not a very satisfactory or enlightening explanation of what Article 23 does, or what a derogation on Article 23 ought to look like. There's similar confusion in the next case, if I could move on to that. This next case cited by the judge is the SS case. Tab 23 in the authorities. And this is cited in the judgment at paragraph 39. What this case was about was a Latvian law that permitted the tax authorities to online advertising services to give over personal details of the advertisers for the tax authorities to check up on them. You get that from paragraph 15 on page 1142. Then you get the questions posed for the CJE in paragraph 29. The first question essentially says, when the tax authorities do that, are they engaging in data processing? And therefore must they comply with the overarching principles of data protection in Article 5. Answer to that question is given in paragraph 37. Yes, they are engaged in data processing. And that's confirmed again at paragraph 47. And then, again, the second question asks, well, can we derogate from what Article 5(1) requires? And then, oddly, we come into a discussion of Article 23. As I've explained to you, Article 23 doesn't actually authorise a direct derogation for anything in Article 5. It only does it, incidentally, to the extent that a derogation from a data subject right might also include, for example, technical breach of the transparency principle. So again, we see some general statements about Article 23 made in paragraphs 56, 57 and 58. It's right that I should show you them, and because the judge himself refers to them, but we say it really doesn't advance matters at all as to what an actual Article 23 derogation should look like. It simply states at the high level of generality, but once again that it's got to be clear and precise in its application and foreseeable for individuals, laying down circumstances and conditions under which the scope of the obligations and rights that may be limited, and then the slightly odd reference to limiting rights under Article 5. The next case mentioned by the judge is the Barra case. He mentions that at paragraph 41 of his judgment. That's at tab 16 in the authorities. deal with this very briefly. This was a case where two public authorities in Romania were sharing data. Romanian tax authorities were sharing personal data, including income data, with the authority that ran the National Health Insurance Fund. It's a case under the predecessor to the GDPR, the Data Protection Directive, and Article 10 of that directive imposed a duty on data controllers to inform data subjects about the processing they were doing. Article 13 of the directive permitted member states to adopt legislative measures that absolved a controller of that duty. The short point here is the Romanian statute law didn't say anything at all about the sharing of income data between these two authorities. So the Romanian government put forward instead its candidate as a legislative measure, a private unpublished protocol between the tax authorities and the health fund. That argument doesn't get off the ground because, of course, it's not law in the required sense. It's just an unpublished agreement. And you see that at paragraph 40. On page 547. Apart from the fact that data related to income are not part of the personal data necessary for the determination of whether a person is insured, it must be observed that the law merely envisages the principle of the transfer of personal data relating to income held by authorities, public institutions and institutions. It's also apparent from the order for reference that the definition of transferable information, the detailed arrangements for transferring that information were laid down not in a legislative measure, but in the 2007 protocol agreed between those two bodies, which is not the subject of an official publication. Now, if I were running the case that our immigration policy document was part of the measure that we did have to take into account when assessing proportionality, well, this case would have some resonance. But that's not our case, and we say that you can't derive anything from this case either as of assistance to the real question in this case, which is what should the measure itself look like.
So, irrespective of the contents of the policy, you say the mere fact that that the Secretary of State's required to have one is enough.
Yes, along with all the other conditions on the face of the regulation. Yes. The last case mentioned in the judgment from the European authorities is one called HK and Procurateur. I'm not going to take your lordships through it. It's another e-privacy directive derogation case, and it says no more than...
Sorry, which one?
HK and Procurateur. It's at 21 in the authorities.
Yeah.
But it's just another e-privacy case that doesn't advance things, we say. So I'm sorry to have spent some time taking you through cases which I say don't actually assist with your task. There's one CJEU case which we say very importantly does, and that's not cited by the judge, but it was relied on by me at first instance. And that is the Ligue des droits humains case at number 22 in the authorities.
So which tab?
22, the beginning of the second volume. This was a case concerning Belgian law that required transport operators to transfer passenger data to the Belgian authorities. And that law was implementing two directives known as the PNR directive and the API directive. And it was the lawfulness of those directives that was under challenge in this case. and I really rely on it just for one key paragraph, which is 114. On page 1099, 114 in the judgment, not the Advocate General. And it says this: it should be added that the requirement that any limitation on the exercise of fundamental rights must be provided for by law implies that the act which permits the interference with those rights must itself define the scope of the limitation on the exercise of the right concerned. So far, so orthodox. But importantly this, bearing in mind, on the one hand, that requirement does not preclude the limitation in question from being formulated in terms which are sufficiently open to be able to adapt to different scenarios and keep pace with changing circumstances. And that, we say, is very much the territory we're in here with this exemption, for the reasons I gave at the beginning about the multifarious circumstances in which it might fall to be applied. And then it continues, on the other hand, the court may, where appropriate, specify by means of interpretation the actual scope of the limitation in light of the very wording of the EU legislation in question, as well as its general scheme and the objectives it pursues, as interpreted in view of the fundamental rights guaranteed by the Charter. And again, an important provision, we say, in this case, particularly given what is said, or maybe being said, about the prejudice test. But when you look to see if you've got a derogating measure that does measure up to the fundamental rights and freedoms that have to be respected, one does it with a purposive approach, looking to see if properly interpreted, the provision you're dealing with really does give adequate protection or not. And we would suggest that if you do take this approach to this regulation, then it can and does properly respect proportionate interference with fundamental rights. That's all I need to show in the European cases, and you'll be pleased to hear we're almost at high grounds, finally. Last bit I need to show you before I begin with the grounds is what the judge himself says after his exploration of the Court of Appeal case in JR1 and the European authorities. You see that at paragraph 42 through to 44 of the judgment. And we say here is the point in the judgment where something goes wrong. He says, by way of summary, a measure restricting rights under Article 23.2 must satisfy the following tests. Be made by way of legislation, yes, of course. Be clear and precise, yes. Legally binding under domestic law, yes. Accessible and foreseeable, yes. And provide substantive and procedural conditions, including safeguards in respect to the relevant processing. Can't take issue with any of that formulation whatsoever. But then this, I emphasise that these criteria are basic rule of law requirements in this context. CJU case law could not be clearer in this regard when derogations from fundamental rights are sought to be adopted. Again, no quibble. These requirements, where relevant, are matters to be satisfied within and by legislation. Again, agreed. And are to be assessed prior to any analysis of the necessity and proportionality of a particular restriction, although the matters are closely related and seen as part of a holistic exercise. That, with respect, is where we say the judge is diverging from what this court has said. Because as I've tried to bring out from the Court of Appeal judgment, that there's that inherent interconnectedness between the conditions precedent, as it's put in Article 23.2, and that goal of necessity and proportionality. You measure what you need by way of detail, substantive and procedural conditions, by way of what is required to obtain a proportionate exemption in all the circumstances.
Although the judge does go on to say it's a holistic exercise.
He does, but holistic is putting it lower than how the Court of Appeal we would suggest. We would suggest it's underplaying the interconnectedness here.
Can we just stand back from this, the analytical level? You may be right, I don't know, you may be right about what the Court of Appeal said, but analytically, certainly in my experience, the courts have often stressed that there is a conceptual distinction between the requirement that something must be lawful in accordance with law, prescribed by law, think formulae of that sort,
yes,
to which the answer must actually be a binary answer. Lord Sumption said that in a Human Rights Act case called CAT.
CAT, yes.
And he said that there is a conceptual distinction between that issue of, if you like, lawfulness and the question of proportionality. Because proportionality often does, perhaps always does, depend on assessment of evidence, facts, particular application of the law. Are you saying, I may be misunderstanding your submission, but are you saying that there is not that conceptual distinction in this context?
In this context, the two really overlap. I mean, we're not actually concerned with prescribed by law here because we've got regulations.
Well, with respect, that again begs some questions, because it's well established that something is not prescribed by law simply because it has a source in domestic law. Much more than that is required.
Yes.
And that's, as I understand it, I may be wrong, so please correct me if I am wrong, but where we see those, what you've called the classic standard orthodox statements of principle, for example, paragraph 132 of Clark Roger, that's all derived, as I understand it, from this fundamental requirement that if you're going to interfere with fundamental rights, you have to do it in accordance with a legal regime which has the sufficient quality of law. And that means not just having a source in domestic law, but that it has to be published, it has to be foreseeable, and it must contain safeguards
yes.
which prevent the risk of abuse.
Yes. So those same elements arise under both questions. Is it law? Is it proportionate?
Right.
And
that's reinforced in this case by Article 23, which says the power can only be exercised by regulations.
yes. So we've got to have regulations. And then we say that the proper thing to do is to look at the Article 23.2 list of matters and think what needs to be included from that list and in what sort of detail to bring you home to an exemption that will only be applied in a necessary and proportionate manner. And we don't discern the judge is really doing that in this judgment. There's the lack of the interdependence between Article 23.2 and Article 23.1 in his judgment, which seems to be so important to the question of what on the list is relevant when the Court of Appeal addresses that in paragraph 54 of the Court of Appeal's judgment. So we point that out as possibly a way in which the judges diverge from what the Court of Appeal said, and we'd urge you to look at that, as I say, at the dynamic relationship between 23.2 factors and the 23.1 ultimate test of necessary and proportionate. Coming now on to three key grounds of appeal. Ground one arises from paragraphs 51 to 57 of the judgment. And
60, sorry, some.
51 through to 57 of the judgment on page 135. What the judge is saying in this part of the judgment is that the use of what I referred to as the limiting formulation to the extent that application of the rights is likely to prejudice effective immigration control. The judge says that's insufficient, in his view, to ensure the exemption is only used where proportionate. He splits that into two complaints. The first, he says, it's unclear as to how much prejudice must be shown. He rejects that complaint, paragraph 55. But then, where he does see merit in the complaint, he says there is no express legislative basis for any balancing test. But my submission below was that those words import a test of strict necessity and a balancing test, because that's how they've been interpreted in the Zor-Lin case. It's not entirely clear at paragraph 56 what the judge is saying there. It's not clear whether he's saying that he thinks Zor-Lin doesn't provide the answer to how this wording should be construed in this exemption, because for some reason he sees some distinction. Or he may be saying that Zor-Lin is right, that is what those words mean, but in this exemption, the Zor-Lin explanation has to be set out on the face of the regulation. In case it's the former, and the judge is saying simply that Zor-Lin doesn't read across to provide the interpretive answer to these words in this situation, can we look please at Zor-Lin, which is in tab 4 of the authorities.
Just before we go there,
yes.
Just going back for a moment to Article 23, and I'm taking it this time from what the judge's quotation of it at paragraph 12 of his judgment, to say, tell you another document.
Yeah.
23.2 says that the provision made, and you've agreed that in the regulations, shall contain specific provisions, at least where relevant, as to, when I go over to G, the risks to the rights and freedoms of data subjects. And you say that's all wrapped up in, to the extent that.
That will be my submission. G is the focus of my ground 3, because there's a particular determination that we failed to comply with G. So I was going to address you in greater detail on what G means and how you comply with it. But yes, for the same reason I was giving you in my medical trials processing example, if you have a potent formula setting out when the exemption can be applied on the basis of demonstrable prejudice, that absolves you of duties you might otherwise be under to be much more specific about other matters that might have to appear on the face of the regulation.
Right, now you wanted us to go to Zor-Lin.
Zor-Lin, please. Tab 4 in the first bundle of authorities. This was a subject access request case under the Data Protection Act 1998, which implemented the Data Protection Directive. And it had particularly heightened sensitivity because the claimants were accused in a criminal case in Thailand facing potentially the death penalty concerning the murder of a British backpacker. And the UK police had liaised with the Thai police and produced a report as part of their family liaison services. And these claimants sought, under the data protection, their personal data contained in that report in the hope that it might assist their defence. So it's a heightened case on its fact, a death penalty case, and that certainly coloured the judge's approach to weighing the relevant factors when he came to that. But we say it didn't affect his construction of the relevant part of the of the directive and the Act. We start at paragraph 58. We have the judge noting that the directive has multiple objectives, only one of which is focused upon the internal market. Critically, the directive is also about wide-ranging fundamental rights, and it points that out. And then in paragraph 60, it follows that the directive must be construed with a broad range of fundamental rights well in mind. It mentions that that may include even Article 2, but at 61, and even if the directive were to be construed artificially with only privacy in mind, that would still lead to a broad and purposive construction. Then we come to paragraph 65 on page 189, where, having identified the data subject rights, which are the predecessors to the data subject rights in the GDPR, we come to the exempting provision, Article 13, which says member states may adopt legislative measures to restrict the scope of obligations and rights where such restriction constitutes a necessary measure to safeguard national security, defence, public security, etc. But that's the directive, and then one sees what the domestic legislation does to implement it. It's section 29 of the Data Protection Act 1998, and that's set out at paragraph 74. And you'll see that it says personal data processed for any of the following purposes over the page are exempt from the first data protection principle, and section 7, in any case the extent to which the application of those provisions to the data would be likely to prejudice any of the matters mentioned in this subsection. So it's the same formula as used in the immigration exemption and many other places in Schedule 2 of the 2018 Act. Mr. Justice Green then goes on to construe that provision, and he does that at paragraph 77 to 78, explaining it's a qualified right. And then this. Although the section and the Article 13 use different language, they are, in my view, consistent. They require a balancing exercise to be performed between the individual's right to access and the data processor's right to refuse. In my judgment, this calls for a classic proportionality balancing exercise to be performed. Then explaining how that has to be gone about at paragraph 84, citing a case of Mr. Justice Mumby called Lord, where it was said the judge held that because of the importance attached to the rights of the individual, it was the data controller who had the burden of proof to establish the right to refuse access, and that the standard of proof was a relatively high one. The test set out in the quote must connote a significantly greater degree of probability than merely more than fanciful, a real risk, something much more significant and weighty that is required. Then in paragraph 100 from Lord, that likely connotes a degree of probability where there's a very significant and weighty chance of prejudice to the identified public interest. And that's then summed up by the judge by saying the burden of proof is thus on the police, in this case to show its entitlement to refuse access, and it must do this with significant and weighty grounds and evidence. So there we see the same words being construed in essentially the same situation, and the test being given is one of strict necessity, where you have to show a significant and weighty chance of prejudice to the identified interests before the exemption can be made out. And we say that reads directly across to the interpretation of the immigration exemption under the 2018 Act, and Mr. Justice Supperstone agreed with that in his first instance decision.
If that's what it means, why don't you say it?
Well, you could say it, but do you need to say it? That's our point. If you're using a formula that has a well-recognised interpretation in law, you don't have to spell it out every time you put it in your statute. Think about how the ECHR cases look at whether something is provided for by law. You look at the law and consider, is this sufficiently public and foreseeable in its consequences to me, with the help of a lawyer standing by my shoulder to interpret it for me if I needed it.
And you would say that's reinforced where there's actually a decision of a court,
yes,
which has actually given an interpretation, because that's authoritative, whereas the advice from a lawyer is not necessarily authoritative.
Precisely so. So we could say it and lengthen the statute to a certain extent, but we say you just don't need to say it in order to have that clear effect.
I mean, sometimes, I don't know if this is helpful or unhelpful, but it just occurs to me that sometimes when we're in the Human Rights Act context, courts are required to give what may be an unnatural interpretation to legislation to render it compliant. That's under Section 3. But you would say, I think, or would you, that that's still the true construction of the statute. You may not, on its face, say that, but sometimes, as we know, you have to read words into.
You apply whatever canons of statutory interpretation are applicable to get the legal meaning. And there's a close analogy with the Section 3 interpretation obligation here. It's the one that I picked out from paragraph 114 of Legality du Humain, but which is, if you are confronted with what appears to be an exempting measure, you must try and construe it in a purposive way that respects the rights and fundamental freedoms that it's there to respect. As I mentioned in opening, there are at least 9 other provisions in exactly this terminology in Schedule 2. They haven't been challenged. The Commissioner doesn't suggest they're wrong in his suggestion. He just says there's something particularly sensitive about processing the immigration field. And we respectfully suggest that's not enough to put on extra burden on the test, on spelling out the test on the face of it here.
Mr. Erdely, speaking for myself at least, I think I would find it helpful if at an appropriate moment your team could just give us a list of those 9 provisions.
We can do that over the short adjournment if that's...
Very kind.
I hope I've counted right. I think it's 9. But I'll point them all out to you. That's what I wanted to say on ground 2. Ground 1. Ground 2 is really probably the heart of the case, and it arises from what the judge says in paragraphs 61 to 65 of the judgment. This is his finding that, contrary to Article 23(2)d, the amended exemption lacks specific provision as to safeguards to prevent abuse or unlawful access or transfer. And the focus of his findings are what he regards as the inadequate requirement to have an IEPD in place. This is where he talks of the outsourcing of the safeguards. As my Lord Justice Singh has already noted, the question of whether there's outsourcing begs the question, well, what safeguards do you need and where are they located? We say all the necessary safeguards are on the face of the exemption itself. In my skeleton, I make 7 points about why we say that this finding is wrong. That's at paragraphs 53 through to 76 of my skeleton. I'll work through them. Some of them need a little more elaboration than others. First of all, contrary to what the judge seems to think, the requirement to have an IEP in place, a policy document in place, it is not a toothless requirement, even though the policy document itself will have the fine detail. The exemption specifies what it means to have an IEPD in place. Perhaps it's just helpful to turn up again the exemption in the supplementary bundle at page 84. It's got to be a document that explains policies and processes for determining the extent, applying the likely prejudice test, and policies and procedures for avoiding the abuse of personal data, etc., where the likely prejudice test is satisfied. It was suggested in argument below that this requirement to have an IEPD in place would be met even if there weren't any actual policies or procedures in existence. It could be a completely vacuous document that simply says the Secretary of State doesn't have any policies or procedures for dealing with this. We disagree with that. That, in our judgment, would not be a compliant IEPD document at all. It simply wouldn't be what is required by this regulation. And there's some support for this from the Bridges case, which you'll find in the authorities bundle at tab 9. Bridges was a judicial review challenge to the use of facial recognition technology by South Wales Police. There was a successful appeal against the first instance judgment, but it doesn't impinge upon the point I seek to make about it. One of the points taken was whether the processing involved in the facial recognition technology exercise was lawful processing of sensitive data under the law enforcement regime for data protection. So the regime that's set out in Part 3 of the Data Protection Act 2018. We're, of course, concerned with the general data protection regime in our case. But you can see at paragraph 138, page 335, that one of the conditions for lawfully processing sensitive personal data in the law enforcement regime is that the controller has an appropriate policy document in place. In relation to sensitive processing, if the controller has produced a document which explains the controller's procedures for securing compliance with the data protection principles in connection with sensitive processing, and then B, explains the controller's policies as regards the retention and erasure of personal data processed in reliance on it. So a similar statutory requirement to have a policy document in place. And then the court looks at what South Wales Police had actually done. There is something entitled Policy on Sensitive Processing for Law Enforcement Purposes. And they say, although this document provides some explanation of the police's policies, the narrative is brief and lacking in detail. We note there's no systematic identification of the relevant policies and no systematic statement of what those policies provide. In particular, the document does not appear to address the position of members of the public. For these reasons, we think it open to question that whether this document, as currently drafted, fully meets the standard required by Section 42. It goes no further than that in this judgment, but I rely on it to show the court there is thinking that a requirement to have a policy document in place, a document that sets out policies and procedures, has built into that requirement some basic standards. You've got to identify relevant policies and procedures and do it in a systematic and understandable way. Otherwise, you may not be able to satisfy the requirement to have a policy and document in place at all.
Was this purely domestic legislation that required there to be an appropriate policy document in place?
This is, yes, it's from Part 3 of the 2018 Act, which implements the Law Enforcement Directive. So it's an implementing piece of domestic legislation, but the wording appropriate policy document comes from the domestic legislation. It doesn't come from the parent directive.
I see.
It's how Parliament has decided to meet the standards imposed.
I don't know if this helps you or not, but I was a member of the Court of Appeal which decided this case, and as you say, we reversed the decision of the Divisional Court.
Yes.
But my recollection is that the arguments were all framed in terms of the content of the policies. So there wasn't an argument, as far as I can remember, in that case, that you couldn't outsource the requirements of law to a policy document. All the analysis was done in terms of whether the policies were themselves adequate.
Yes, I'm not suggesting this case stands for authority that one can outsource, but the reason I take the lordships to it is simply to demonstrate that a requirement to have a policy document is not without substance.
I see.
As I say, the Divisional Court goes no further than that for the reasons it explains in 140. It says the ICO might be looking to give some more guidance about what a policy document should have, and they leave the matter there, and it's again parked in the Court of Appeal. It goes no further. But as I say, I rely on it to resist the suggestion that a requirement to have a policy document in place is some kind of vacuous requirement with no force whatsoever. The second point I make in my skeleton is why we say the judge was wrong to dismiss the requirement for policy documents to be insufficient. Comes from what he says in 64(1). He says recitation in paragraph 4(1)(b) of the term abuse of that personal data, reflecting Article 23(2)(d), does not give that term content or meaning. It is perhaps slightly confusing that one of the requirements of the policy document is that it should address methods of preventing the abuse of data or access or transfer to it, because that does indeed mirror the wording of the Article 23(2)d itself. But that's not, we're not outsourcing that requirement there. The requirement to deal with prevent abuse of personal data, etc., or unlawful access or transfer is met, we say, by the combination of various tests and conditions set out on the face of the regulation. Third point I make is that the judge is wrong to say in paragraph 64(2) that there's no appropriate analogy between the requirement for policy documents in this exemption and the requirement for policy documents in other parts of data protection legislation. We've already come across one of those requirements in the Bridges case. Can we now look at a similar requirement that arises under the general data protection regime? To do that, we need to look at Article 9 of the UK GDPR, tab 32 in the authorities, page 1570. This is Article 9 of the UK GDPR, and it imposes a prima facie prohibition on any processing of special category data, as it's called, so racial or ethnic origin, political opinions, etc. Article 9.2 then has a list of situations in which that processing that may be permitted. And 2G has where processing is necessary for reasons of substantial public interest on the basis of domestic law, but which will be proportionate to the aim pursued, respect the essence of the right to data protection, and provide for suitable and specific measures to safeguard the fundamental rights and the interests of the data subject. So there we've got a prohibition on certain type of processing and a derogation from that in terms strikingly similar, you might think, to Article 23(2). And the Data Protection Act 2018 does have a provision that corresponds to this derogation. It's in section 10 of the Act, which is at tab 29, page 1191. And you see section 10, little 3, processing, that's processing the special category data, meets the requirement in point G of Article 9.2, that's what we were just looking at, for a basis in the law of the United Kingdom or part of the United Kingdom, only if it meets a condition in Part 2 of Schedule 1. We then go to Schedule 1, which is on page 1215. I beg your pardon, we need to look at 1217, headlined Substantial Public Interest Conditions. This is the part of Schedule 1 that sets out a number of different situations in which special category data can be processed on public interest grounds. And it starts in little 5.1, except as otherwise provided, Condition as part of this schedule is met only if, when the processing is carried out, the controller has an appropriate policy document in place. And then, since we're on the page, you can see the very derogation that the Home Office will be relying upon when it processes sensitive personal data, special category data, is in paragraph 6. Condition is met if processing is necessary for a listed purpose and reasons of substantial public interest. And those purposes include the exercise of the function of the Crown or Minister or government department. The schedule says, as is foreshadowed there, a little bit more about what a policy document must look like. We get that on page 1231. Paragraph 39. The controller has an appropriate policy document in place if the controller has produced a document which explains the controller's procedures for securing compliance and explains the controller's policies as regard retention and erasure, giving an indication of how long such personal data is likely to be retained. So again, quite familiar language here. And then there are some additional things that have to be done with a policy document. You get that in paragraph 40. You have to retain it, you have to review it, and you have to make it available to the Commissioner. There's not even any requirement to publish this document. And it's on the basis of that provision, with a policy document in your back pocket, that you can process the most sensitive personal data of individuals.
Well, no, those are authorised, as you said, by Article 9. And if you go back to Article 9, page 1570, G was a particular paragraph of 9.2 that you took us to.
Yes.
The processing must be proportionate to the aim pursued and provide for suitable and specific measures. Now, the article that we are concerned with required legislative measures, which now has been transposed domestically as to require regulations.
Yes.
Measures is not quite so specific, is it?
We would suggest that it is specific here. It means legislative measures because it's got to be a basis in domestic law.
Why did old Article 23 talk about legislative measures rather than measures?
Because they're measures that have to have the quality of law, and we would say that that's implicit here as well. That it has to have the same quality of law. It would be odd to allow processing sensitive personal data to go ahead on the basis of some non-legal measure and require a legal measure for the processing, for the exemption of data subject rights. They must surely stand or fall together, we would say.
And I think you would submit that in the context of EU law, at least, one never construed things in a simply textual way, that you construed them by reference to the general principles of community law. And I think you would say that one of those is the quality of law point.
Yes, it's well recognised as a principle of EU law that then governs the way you construe in a particular language in a provision. But yes, we would make that point.
But what's the point of having... Let's assume, for the sake of the argument, that the presence of these statutory references to having an appropriate policy document in place is lawful, where it appears elsewhere in the DPA. But what's the point of doing that? What's the underlying rationale of why you're having it? If it's not that it helps to supply what would otherwise be missing, in other words, it's part of fulfilling the requirement of the quality of law, why else do you have it?
Well, the requirement to have it there is because having a policy and having to follow it promotes good decision making on a case-by-case basis.
And also consistent decision making.
Yes, we would say so as well. And it gives a level of scrutiny because in this case the Commission can say, please can I see your policy document and your record of processing. Again, in the case of our exemption, you actually have to publish the policy document and you have to keep a record of when it's been used. So that all, we say, that brings in considerable rigour. Whatever the policy document itself says, the fact it's got to be there, has to be published, has to be had regard to. I'm coming on to that point.
So effectively what you're saying is, your submission isn't that the policy document helps you to overcome the hurdle about quality of law. You're saying it's an additional safeguard, in effect, because it provides for coherent, consistent decision making and helps decisions in individual cases.
Yes, the requirement to have a policy document and to have regard to it, etc., all adds to the substantive and procedural safeguards that are required in a measure such as this. My next point will then be to make some submissions on the duty to have regard and why we say the judge understated it in his judgment. I'm conscious of the time. Well,
Don't pay any attention to that clock.
I did wonder.
Wildly out. My watch says it's 10 to 1.
Very good. I can make some more progress. Yes, there is on the face of the regulation a duty to have regard to the policy document when making decisions about whether the exemption applies. The judge refers to that as a soft public law duty. And although we understand what he means by that, we think he has underplayed its potential to make a difference in a case like this. The case I cited in my skeleton argument on this point is the Royal Mail case, the first of the authorities. This is a case in which the postal regulator had fined Royal Mail for breaches of a licence. And Royal Mail's case was that in doing so, the regulator had failed to have regard to its own statement of policy about the imposition and calculation of fines, despite the relevant statute saying that the regulator did have to have regard. You can see that at paragraph 7, setting out the relevant statutory provision. Between the two whole punches at 31, the Commission shall prepare and publish a statement of policy in relation to the imposition of penalties. And then 2, in deciding whether to impose the penalty and deciding the amount, the Commission shall have regard to the statement of policy. There's then a helpful survey of the cases where that wording and similar statutory wording appears. That starts at paragraph 29 through to 33. And so, for example, commenting on the Munjaz case, paragraph 31, top of page 19, the judge says, final sentence of that quote is of considerable importance since it recognises the context of and circumstances in which the guidance is applied are highly material. Since in Munjaz's case the liberty of the individual was an issue, it was the more necessary to have and to give cogent reasons for not following guidance designed to give protection for the detainee. And we would say we're in a similar context here because we're in the realm, as we accept, of derogations from the fundamental rights of data subjects. But all the more important when you're having regard to be able to give cogent reasons if you decide to depart from your policy. And then distinction between guidance and law is explained in paragraph 33, and it's right, of course. Guidance cannot bind a public authority to act in accordance with whatever the circumstances. To suggest otherwise would be to distort the concept of guidance. Equally, an obligation to have regard to a policy is not the same as an obligation to follow it. I completely understand that. However, the context and statutory provisions in question are vitally important. Policy can't normally be applied without the possibility of departure, because it would mean that the body in question had fettered its discretion to act. But then the judge looks at the particular circumstance of this case, and towards the end of that paragraph, to a very large extent, Parliament's indicated how Postcom's discretion should be exercised. The obligation to have regard to the policy recognises there may be circumstances when it doesn't have to be applied to the letter, but in my view there must be very good reasons indeed for not applying it. And we would say we're similarly in a situation here where having regard to means follow unless very good reasons not for doing so.
I'm sorry to take you back to paragraph 31,
Yes.
where there's reference to the House of Lords decision in Munjaz.
Yes.
I was reading again the quotation from Lord Bingham in Munjaz, and that's a case that's frequently cited in this context. But am I right in thinking that in Munjaz there was a requirement to have a statutory code under the Mental Health Act?
Yes, that's right.
Yeah.
So it's not, we completely accept it, it's not applicable here, but it's interesting, we say, instructive to see what this judge takes from that case in a case where he is construing a statutory duty to have regard.
I understand that submission, but the reason I ask is that in our case, the judge appeared to suggest that one way that the government could solve the problem, which he said is a problem, is to have a statutory code.
Yes, and again, that is one way. If there's a problem, you could certainly have a statutory code, but it's rather like the answer gave to my Lord Justice Lewison as to why we can't spell out more of the test from Zor Lin on the face of the regulation. Well, we could, but we don't have to, we say. Likewise, we don't have to have a statutory code because there's enough there on the face of the regulation. Can I just quickly, before short adjournment, whip through the two cases that the judge does cite in support of his reason for rejecting the duty to have regard as being a soft public law duty of not much worth. The first one that he refers to is bracking, which is at tab 3 in the authorities, page 138. Bracking concerns the public sector equality.
So sorry, which tab is this?
Tab 3 in the first bundle of authorities.
Thank you very much.
Bracking concerns the public sector equality duty under the Equalities Act 2010. That is not a statutory duty to have regard to anything. It's a duty to have due regard to various factors. It's not a have regard to a policy case. It's have regard to various factors. You can see that at paragraph 24 on page 149, where that's set out. It's in the exercise of functions, authority must have due regard to the need to, and then 3 types of very, very broadly put considerations indeed. So it's not surprising at all that then when the court considers what that might mean, they cite on page 152 a judgment about such a case. And over on page 153, the concept of due regard requires the court to ensure there's been a proper and conscientious focus on their statutory criteria, but if that is done, the court can't interfere. Well, absolutely right, when what one's having to do is have regard to various high-level factors when exercising one's functions. That's not the case that tells you what a duty to have regard to a published policy document consists in. And the other case the judge cites is the Good Law Project case.
Shall we look at the other case at 2 o'clock?
Yes, by all means.
2 o'clock.